Okay, American Jurisprudence, Replevin. Interaction. There we go. Okay, Replevin. So, what is a Replevin? Does anybody know? Anyone want to give a guess in the chat before we start? No? Good. I didn't think so. Because I never knew what a Replevin was. I actually learned about a Replevin from an experience that Chili DeCastro had when he was in Delete Laws, and he had his property taken from him in Ironton, Ohio. And someone had mentioned this, and it got me thinking about it, so I did some research on it. I don't know what 5x5 means, but as long as I know there's people that chat, I know I'm coming through. So it drew me to find out more about a Replevin, and what I found was just a lot of nothing very direct about the foundations and where it comes from. But let's get into that, because I found this American Jurisprudence on it, and this is probably one of the best references you can get. I really believe that by studying this volume, what we have in front of us right here, you'll probably know more than 90% of the Esquires out there when it comes to a Replevin. So let's get to this. So what is a Replevin generally? Let's see how the screen looks here. I gotta move it a little bit. Just a moment. Just checking out the YouTube because it varies a bit from what I see here on my studio. Okay, good. Okay, a Replevin is a remedy stemming from common law. Okay, we have a reference here which we'll go to really quick. Oh gosh, all the way at the bottom here. So this comes from Three States Lumber Company versus Blanks. This is 1904. And Rawls versus Ogden, Mississippi, 1973. So this is the reference that they're talking about here. So let's get back to where we are. I'm not going to do that for everything, but that's generally what you're doing when you're referencing these documents here. I'm going to try and fill in as much as I can just from my memory to help out and move along. So a claim for Replevin involves an entitlement to property, and that demand for the return of the property has been made and refused by the possessor of the chattel. Chattel is tangible property. Let's see where they get chattel from. We'll have actual case law for the chattel. Of course, if we want to know what chattel is, we could always refer to Black's Law Dictionary and look up chattel. But I'll just tell you right now, it's going to be some type of tangible assets, gold, silver, something that can be movable. So despite its common law, or your cell phone, let's say a cell phone in this case, would be something that would be taken from you, and you make a demand for them to return it, and they won't. So, despite its common law origin, in some jurisdictions, Replevin is strictly a matter of statutory law. So, depending on your jurisdiction, you might have statutes that actually address Replevin. So, you would check on that first, because if there are statutes there, that would be a remedy. An action for Replevin is a civil action. So, in a federal system, the court's authority to award Replevin is provided for by the Federal Rules of Civil Procedure. Now, if anyone has any kind of case in a federal court, this is essentially your Bible you have to always have available, because that's where you're going to learn how to follow the rules of the proceedings within that federal court. The Uniform Commercial Code, the UCC, is not intended to supplant remedies or to override those remedies, such as Replevin. Rather, it serves to supplement them. So anything they're provided within the Universal Commercial Code that might apply to the situation would not override your remedy for a Replevin. It would rather supplement or add to it. So here's an observation. This is what's beautiful in American jurisprudence, is that you get these great little things in here. Let's see how this one is. The prima facie evidence for Replevin are ownership of the property, a right to its possession, a demand on the respondents for its surrender, their refusal to surrender it, and their consequent wrongful detention of the same. So the elements for your Replevin, right? So the first thing is you own the property. You have a right to its possession. You made a demand to the people that took it from you for its surrender. and they refuse to surrender it. And consequently, they're detaining it wrongfully. Okay, so we got that down. Oh yes, everyone, please hit the like button if you could. Let me, I'll even throw that in here. Matter of fact, let me test out the chat on this apparatus I got here and see if it's going to do the same. Give me one moment here. I can view the chat. Chat. There it is. Okay, and okay, let's connect there. There we go. Okay, cool. And I can go to live chat. Beautiful. And I can say hit the like here, right? And there it is. I mistype it, you know what it means. All right, let's proceed. Thanks. Okay. So a replevin is not a term that can be equated or used interchangeably with attachment, receivership, custodianship, or injunction. It is a remedy that is designed to restore possession of property to a party entitled to possession. A replevin action is not one strictly for money damages. Okay, so you're involving property, but not strictly for money. It could be for money. Someone seizes money from you, and they're holding that money unlawfully, and you would be able to use a replevin action in one way or another to obtain your possession or return possession to you. So, by the way, any questions, feel free to throw them in the chat because I am monitoring the chat here. So, although actions in replevin are restitutionary in character, they are classified as tort actions. So, despite this classification, an action for replevin can be based on a breach of contract. You get that? So, if there's a breach of contract and someone has possession of your property, you could use the replevin to return that property to you based on a breach of contract. Stated another way, replevin sounds both in tort and in contract. That part of the remedy that provides for recovery of possession by replevin sounds in tort, and that part that provides for damages for the detention of the property sounds in contract. The cause of action is based upon the illegal acts of the defendant. That means a person that took your... Hang on a second. Let me read this before I give you that. So the cause of action is based upon the illegal acts of the defendant instituted by a plaintiff to obtain from the defendant the property that the defendant possesses. So in this case, even if you were arrested and they took your property unlawfully in the course of, say, an unlawful or questionable arrest, then in the replevin action, they would almost be considered a defendant, and you would be the plaintiff in this. I also see that there might be an opportunity to use this in maybe an affirmative defense also, because it's another cause of action, and these elements that would be in a plaintiff's claim would be the same that would be in an affirmative defense. So this is something to keep in mind, that if you have to make an affirmative defense, or you have to respond to a complaint or a plaintiff's action, that you might want to include the replevin for return of property in your response to that, your answer. Further, the primary purpose of replevin proceeding is to test the right of possession of personal property and to place a successful party in possession of that property. So let's think about this for a second. It's to test the right of possession. How do we test the right of possession, right? You have to basically put it through the crucible. You burn off everything and let the scum rise to the surface. At that point, the real stuff is at the bottom and the scum's at the top, and it's visible now. So we're able to use that test for right of possession to determine which party should have the possession of that property. So, caution. These precautions are the important part to remember when you're thinking of these principles, because this is the pitfall you want to be aware of. Replevin is meant to determine the right to possession of property and does not necessarily involve title. So think about that for a moment. possession and title. Two different things, right? Car, vehicle. The primary relief sought in a replevin is the return of the identical property, and damages are merely incidental. Thus, strictly speaking, a replevin action is not a suit for monetary damages. In at least one state, replevin actions are in rem actions, meaning about property. In rem is for property actions, used against the purpose of obtaining possession of the specific property rather than compensation and damages for its loss. So instead of most lawsuits where you're trying to obtain monetary damages for remedy, the remedy of a replevin action is to return property, and that's it. And in the course of that, it will not determine the right of ownership, only that the right of ownership belongs to the person making the claim at that time, as opposed to the person holding it and possessing it. It does not establish title. So I think everyone should be, this is an American jurisprudence. Let's see which one we're in. We'll tell us at the top of this next page because we're getting right to it. There it is, 66 AmJur 2D Replevin. And I believe we're looking at the 2022. Yes, we're in 2022. So this is the revised 2022. We're looking at the most current. So these are all the case laws that we would refer to. Replevin suit simply seeks to recover goods from one who wrongfully retains them at the time the suit is filed. See? So this is important stuff to know here. This is, these are actual precedents that have been set in case law. These precedents in and of themselves don't make the law. What they are ways that interpreted the law that have been basically verified through the judicial process, so that when you make a similar argument, you refer to these as saying it's not just my interpretation of the law. This is obviously what these other appellate judges ruled, and in their wisdom, they seem to have come to the same conclusion I have in this situation. Therefore, I, the court rules in my favor. So let's see here, the nature of a replevin. So here's where we get to the good stuff. I hope I'm not boring anyone here, because I don't see the chat moving at all. Is there any questions from anybody? And is there anything I need to do to bring everyone to the subject again that we're on, so that we know what we're talking about here? Or maybe my chat stalled here. Let me double check. Okay, let's continue. Nature of a remedy of replevin. So the proper action to reclaim possession of a property based on an unlawful seizure or detention is an action for replevin. So let's read that again. The proper action to reclaim possession of property. So the proper action to reclaim possession of property based on an unlawful seizure or detention is an action for replevin. So replevin is the action when something is unlawfully seized from you or detained from you. Property, not people, property. Replevin is, and historically has been, a possessory action for the recovery of specific property. A replevin action provides the means to obtain possession of specific personal property that one has a right to possess, and where one's claimed title to, and the right to immediate possession of specific personal property which is wrongfully detained from that person. The person has the right to recover possession of that property by an action in replevin. So the observation is replevin is an action for possession where the factual question that must be resolved is which party is entitled to possession of the disputed property. Do you see how simple this becomes? Replevin is an action for possession. All right, listen, this is... I mean, you could go to law school for many years, or you could sit here and read these books and dig through them, which would be, I could see how people could get buried. But this sentence right here pretty much sums it up. And just this part right here, the factual question that must be resolved is, this is it. Which party is entitled to possession of the disputed property? So let's say law enforcement unlawfully seizes your phone. Are they factually entitled to the possession of that property? Really? Is it factually entitled? Where does the entitlement come from? And can they present those facts to the court? Because otherwise, you would be able to present facts such as a bill of sales, a sworn affidavit, etc., establishing that you would have the factual entitlement to possession of the property. So this is a critical element to understand of Replevin, is that it's an action for possession where the factual question that must be resolved is which party is entitled to possession of the disputed property. Okay, let's continue. An objection of an action of Replevin is to recover specific personal property. I'm sorry, let me reread that. The object of an action of Replevin is to recover specific personal property, and liability for the value of the property accrues only if the return of the property cannot be had. Think about this. The liability for the value of the property accrues. So if you are making money off of the use of that property, then the value of it accrues only if the return of the property cannot be had. Thus, plaintiffs can recover both damages and repossession of their personal property. And in the sense, Replevin is a Replevin is partly an action in rem, meaning with property, and partly an action in personam, meaning within the person. This is the jurisdictionary terms here. In other words, Replevin is an action for goods wrongfully taken. It entitles a party to the return of the goods, as well as damages for the value of use of the goods during the period of detention. Okay, guys, now you don't need to be an esquire to understand this. I get the first sentence. Thus, plaintiffs can recover both damages and repossession of their personal property. In that case, Replevin is partly an action in rem and partly an action in personam. Means nothing to most people. This sentence, however, should. Listen carefully. In other words, Replevin is an action for goods wrongfully taken, and it entitles a party to the return of the goods, as well as damages for the value of use of the goods during the period of detention. Does that seem simple enough to understand for anyone, or is that something you'd have to hire an esquire to be able to interpret? I mean, it's pretty cut and dried to me. Something is wrongfully taken, and I'm entitled to the return of those goods. And if I've lost value due to the detention of those goods, then I'm entitled to damages as well. However, despite the dual nature of the remedy, that is, a successful plaintiff may recover damages for the wrongful taking and detention of the property as well as recovering the property, the primary purpose of the remedy is to recover the property in question. Likewise, the primary purpose of a Replevin statute is to test the right of possession. You get that? Test the right of possession of personal property, in rem, in personam. Property, right? And the personal. So we got both those elements here, and place a successful party in possession of the property. Primary purpose of a Replevin statute. So if you find a Replevin statute in your state statutes, then the purpose of that statute is to test the right of possession of personal property. And it'll be able to remedy it by placing the action to place the successful party in possession of the property. And now it's going to be done through an order, right? Replevin is an action at law, not in equity. And a plaintiff may seek equitable relief only if the chattel is unique. In other words, see, right, that first sentence means nothing to you. But the beauty of American jurisprudence is that they interpret it so that even a common person could understand this. Because in technical terms, a lawyer is a layman. No different than you and I. Actually, even below us, perhaps, they may be. Let's continue. In other words, If replevin is complete and it is an adequate remedy at law in the case, the court may not exercise its equitable powers. Thus, the general rule is that when a title to personal property of an ordinary character is in dispute, and the title asserted by the respective parties is strictly a legal title, the remedy of the party out of possession is at law by an action of replevin, and the party cannot maintain a suit in equity to establish ownership. So when we're talking about these equity and such, this is when you're talking about, this is going to run more into parties with different balance of power and such in this. We'll have to get in here a little bit deeper before I interpret that. However, rules governing replevin do not bar a separate action in equity where equitable relief, such as injunctive relief, is available. Okay, so here we go. Additionally, as an action at law, a court cannot provide remedies not specifically enumerated by an applicable replevin statute. So let's let's repackage this here because I kind of got ahead of myself as I was reading it. So without having insurance, this has nothing to do with insurance or indemnity right now. So the general rule is when you have title to personal property of an ordinary character is in dispute, and the title asserted by the respective parties is strictly a legal title, the remedy of the party out of possession is at law by an action of replevin. Okay, so the remedy is at law by an action of replevin, and the party cannot maintain a suit in equity. So the equity would be like an injunction or some other type of court remedy aside from money, right? That would be the relief. But it's basically saying that the replevin is the proper way to address this, not an equitable suit for injunction. So if that makes any sense, the fact is that if you know that what you're talking about here is a specific issue of property like we're talking about here, then you probably aren't going to be dealing with this court of equity. And I'll tell you what, these days it's hard to even get them to recognize a court of equity case. All right, so let's get down here to the next section here. This replevin distinguished from an action for claim and delivery. So this is a big distinction here. Now, I doubt most esquires probably know this distinction. So we have a lot of good stuff in here, but this is an action in claim and delivery is an action at law for recovery of specific personal property. Claim and delivery is a remedy by which a party with a superior right to a specific item of personal property, most commonly created by a contractual lien, may recover possession of that specific property before judgment. The prime concern with these laws has to do with the reclamation of property without first affording notice and an opportunity for hearing. The primary purpose of claim and delivery statutes is to provide a method for obtaining possession of a specific personal property. Okay, so are we following along here? Probably not, but try to, because we're going to get clear as it goes on. This is the way American jurisprudence works. It's going to be very specific and very legalese kind of as it starts, but as you break it down, it's going to make it more and more understandable so that when you go back over the primary introduction of these concepts, along with the references, it's going to make perfect sense. The thing is, all these little, it's hard to see the little footnotes they have here peppered throughout. These footnotes are going to be your case laws you refer to when you're using any of these particular arguments for your cases. This is the way you make your paperwork look better than most of the esquires. And let me tell you what, if you really read the case laws that most esquires fluff up their paperwork with, you'll find out they probably don't even apply. And if you come about writing up things where you're getting this stuff right from American jurisprudence, I mean, everyone's going to be impressed. And I believe that your argument's going to be standing on its own merits more than, having a title of Esquire behind you. And you're not going to be arguing, based on persuasion, but based on facts. And that's going to be the winning argument. So let's see here. Replevin, a procedure by which seized goods may be provisionally restored to their owner pending the outcome of an action. Yes. Now, what we're talking about here is actually the nuts and bolts of it, because it's nice to know the definition of it. It's nice to know how it's, can be used, but how would you use it, and where would it apply to you? And I'm trying to use some very common things that we find people in the 1A community dealing with when their property is seized unlawfully and going about getting it returned. And I've seen time and time again, nobody has even used the correct remedy for it in our courts, which is the replevin. The replevin could be used, as we've seen here. It could be even used in your answer to the complaint in an affirmative defense. So the replevin is your first course of action to get your property back. The longer they hold your property, the more you can even add to the claim for damages now on top of it. But the primary reason of the replevin is to get your property back in your hands. If you don't know this, and property is taken from you unlawfully, and you try to get it back through legal means, and you're not aware of the replevin, you'll be using the wrong legal means most of the time. The sad part is they probably know this, so they know until you do the replevin, they know they could just string you along without a remedy. When you know about the replevin, you find out how simple this is, which we're about to get to, because the beauty of American jurisprudence is that we're going to have some great pleadings and stuff in here and examples that show you exactly how to make it. And the great thing about this is that, literally, I've spoken with esquires that know nothing about this. And if you go to one of these guys thinking that they're going to help you, you might have another thing coming, but I can't say for sure. Let's see here. So an action in claim and delivery is we've read that part. Okay, so it has been said, a claim and delivery action to recover possession of personal property is a modified form of the old common law action of replevin. So there's claim and delivery action and replevin. And now we're going to figure out the distinction here, okay? However, in some jurisdictions, an action for claim and delivery is an entirely new and more comprehensive form of action than replevin, and was enacted to provide a new form of action whereby the entire controversy would be settled in one suit, thereby preventing the necessity of multiple suits and appeals arising out of the same subject matter, which often resulted in the old replevin statutes. The remedy is not without its limits. For example, claim and delivery will not lie to recover possession of a property seized by the government. Look at that. So maybe an esquire would say, we got to do a claim and delivery action, but the government took your property, so boom, denied. However, if you did the replevin, perhaps you would get it back. So let's see what we got here. A procedure allowing you as a provisional remedy to take possession of the property prior to judgment on the action. Exactly. And that's why you want to get this in as soon as you can. To vow, pledge, release by giving certainty. Great. I'm glad you guys are doing that. So I don't like to have to get too far off topic. Normally I do have Black's Law, and I'll have a dictionary, an old dictionary next to me, like a old Webster's, and I'll have a few other references nearby for this, because you do come across words you don't know. Some of these words I do know, I'm trying to fill in for the listeners so we could all stick along with this. Okay, so once again, let me reaffirm this part for your notes. The remedy for claim and delivery is not without its limits. For example, claim and delivery will not lie to recover possession of property seized by the government. Simple. Is that simple enough, or do you have to hire an esquire to explain that to you? In an action for claim and delivery against a defendant, this is the government, let's say in this case, or maybe the policy enforcers, who did not come into possession of a property wrongfully, but wrongfully withholds its possession, the plaintiff must ordinarily make a demand for the return of possession. A demand for the return of possession. Further, in some jurisdictions, an action for claim and delivery is subject to a statute of limitations. Title and right to possession at the time of action is brought is sufficient to sustain an action for claim and delivery of a personal property. So a title and right to possession, right, is enough for a claim and delivery. Additionally, the right to immediate and exclusive possession of a property must exist when a plaintiff brings an action of claim and delivery. So the right to immediate and exclusive possession, so that's something you must ascertain with facts, that you have a right to immediate and exclusive possession. Like the action of Replevin, the action of claim and delivery may not be maintained against a stranger by one joint owner of the property without joining as plaintiffs a co-owner or co-owners. So joining contracts, right? You have to be the owner. It can't be a stranger making a Replevin action or a claim and delivery action, right? But that should be well understood. So it's good to be researching while you're listening, because that's what you should be doing. It's normally what I'm doing, but again, it would break the continuity of what I'm trying to get across. And I think if you're taking notes, you'll be able to do your own research. Again, Audit Them has some beautiful AmJur books that I know he's going to be going over in the future while he's setting up his studio. And in the meantime, I just wanted to give a little preview of what we can be going over. So, in some jurisdictions, although portions of the claim and delivery statutes have been declared unconstitutional, do you get this? So, how would you know this? Well, here we go. Footnotes will be in here. See, here we go. Goldie versus Botchet Properties. This is in 1975. Noting that in California, judicial decisions have only declared unconstitutional the provisional remedy of claim and delivery, and not the underlying substantive action to recover specific property. The provisional remedy of claim and delivery. So we'd read this case, which is in the AmJur, and the reference is right here to get to it. Of course, we're not going to look at that now because I pull up a different volume. But again, Audit Them has this because this is 1975, and I'm sure his is after 75. So we could pull this actual case and find out about it being unconstitutional. Here's as to the right of a person to recover exempt property by Replevin. So any of the pitfalls you might have, you can actually kind of spend some time. You go over all of these. If you went through every case here and see if any of it applied to your situation, then you could pretty much rule out 99% of any of the pitfalls that you might come against. And it's nice when you can go in there that airtight. So, debt to new. Okay. Here's something new here we got. And in this one here, it comes up to something that's going to make it a little difficult to keep talking about, because I don't know how to say this word properly. So we're going to have to get a Black's Law and look at a pronunciation for this word. Sorry, guys, but it's in there too many times. And what is the word we're looking at here? See the D. Move over here. And we all need to know what this word means too, because recovery specific detenu. We're going to find out what it is in just a moment. Hang tight. Has everyone hit the like yet? If you haven't hit the like, please hit the like so we can find out if people are actually listening right now. I know I get a few people here. I need mods, huh? Oh, that's an easy thing to do, right? Let's see. There we go. That works. The question is yes. Okay. I did it right. What do you know? Chat. There we go. So a writ, marshal's custody, yeah. Very good. I just want to know how to say it because I'm going to be saying it over and over again, and I hate mispronouncing words over and over again unless I'm doing it on purpose, like Audit Them will do, just for emphasis. But I don't know the meaning of the word either. We get the meaning there in the chat. I didn't see the pronunciation. It's detenu. or detenue. Detenue. I got it. It's a claim in detenue, right? Okay, so it's a common law action to recover personal property wrongfully taken or withheld by another. That's what we got, right? Okay, so that's what detenue. A detenue is a common law action to recover personal property wrongfully taken or withheld by another. So it's also a replevin trover. A claim in detenue lies at the suit of a person who has an immediate right to the possession of the goods against a person who is in actual possession of them, and who, upon proper demand, fails or refuses to deliver them up without lawful excuse. Detenue is, at the present day, has two main uses. Are you ready? In the first place, the plaintiff may desire the specific restitution of his chattels, that's the property, and not damages for their conversion. Conversion. So if your property was converted to something else, you want the restitution of your chattels, not damages for conversion. He will then sue and detenue, not intro. Wow. Okay. So we don't need to go any further on that. So we got things like detenue of goods in frank marriage, which is a writ allowing a divorced wife to obtain the goods given to her during the marriage. How about that, guys? Yeah, detenue is of goods in frank marriage. It's a writ, meaning something written by a judge or a court, allowing a divorced wife to obtain the goods given to her during the marriage. Wow. Then there's the detenue sur bailment, and that's an action to recover property that the defendant acquired by bailment but refuses to return. Interesting. Okay, so that's the nice thing about having that Black's Law nearby. Yep. Let's see what we get here. Say replevin over. Yeah, it doesn't sound like a word, does it? Replevin. Yeah. Actually, try to say boy boat 10 times in a row. See how that sounds. Okay, so back to detenue. Or detenue. Sorry, detenue. Detenue. Detenue is a common... that doesn't sound like a word either. So, let's get here. Replevin, distinguished from detenue. So we heard about some of the historical uses of detenue, right? So a divorced wife to recover goods from her husband, ex-husband. So a detenue is a common law action for recovery of a specific personal property unlawfully detained or its value, and for damages for its detention, and for damages for its detention. In this respect, it is similar to replevin. However, the peculiar and distinguishing characteristic of the latter is that it takes the property, the latter is replevin, is that it takes the property in controversy from a person who, by the person's possession of it, is prima facie its owner, right? On the face, right? It is prima facie its owner and places it in the hands of the plaintiff, substituting in its stead a personal security in the form of a bond to the defendant for its return, if such shall be the final judgment of the court. So let's read this again. I'm sorry. However, the peculiar and distinguishing characteristic of the latter, the replevin, is that it takes the property in controversy from a person who, by possession of it, is the prima facie its owner, and places it in the hands of the plaintiff. Okay, so in its face, so they're holding it right now, in fact, right? And it places it in the hands of the plaintiff, the person that originally had the goods that was taken from him, substituting in its stead, this is the detenue, a personal security in the form of a bond to the defendant for its return, if such shall be the final judgment of the court. Oh, I'm sorry, no, we're still talking about a replevin here. While in detenue, the possession is not changed until after judgment. Okay, so we get this distinction pretty clear now. The words itself get a little confusing, and not pronouncing Latin commonly makes it a little difficult to read. However, what we're saying here, the distinction between a replevin and a detinue, is a replevin is going to get your property right away, and a detinue will do it after judgment. We got that? Detinue is not a good sounding word either. It's French. So we got that then. A replevin, you get it right away. A detinue, after judgment. And there's a bond held for a replevin too. That could be part of the deal too. That let's say that if the cops take your phone from you and it ends up being that they should have had the phone because it was used in the commission of a crime, then you could get a replevin order to have that phone returned to you because you use it for other purposes and there's nothing contained in that phone that would be part of that crime. And that if they win the case at the end, then you have to return the phone and you would have to post bond for the phone. That would be held until the end of the case. That kind of thing with a replevin. Whereas the detinue, there would be no bond or anything that you would be able to place. You would just have to wait until after the judgment is made. So as with replevin, a party claiming a property must have a title to it, or else the party cannot maintain an action in detinue to recover the wrongfully taken property. So you want title, ownership, that kind of thing, some proof of ownership, facts that you should have ownership and not them. So let's continue here. So the good thing is we have our footnotes. As the property recoverable under detinue, right? As the requirement that a plaintiff in a replevin action, that's you, have title or a right to possession of the property. Generally see this. So this is the stuff you want to see. Vessel found in water. Look at this, 1999. As to the requirement, generally, that one who brings an action of detinue must show an absolute or special property in the goods with which to immediate possession. So again now, we have some cases from 2007 in here, 92, and 1860. Do you see how this works? All these cases will be found in American Jurisprudence within those volumes, so you could read the actual opinions within those cases. When you're reading that stuff, if any of those apply to your particular case, do you realize what excellent arguments you make to back up your allegations with the facts and the reasoning behind the interpretation why the law applies to you? So this is where literally the rubber meets the road when it comes to law, and that you can't just hire an esquire to do this stuff because it takes too much time and effort for them to do in most cases. Some may, but you will. So let's see where we're at here. So replevin distinguished from trespass, trover, and conversion. Now this is important here. Are we all still there? Just curious because I see we got some, looks like people dropped out, or we still got people here. You can always hit a 1 in the chat or something if I know you're there. I'm going to continue now with replevin, distinguished from trespass, trover, and conversion. Where it goes back to the 1500s. Oh, yes. But the case laws that we can actually refer to in American jurisprudence in this particular issue go to 1860. They're going to be in this actual text here. So these are like, you start quoting these cases to back up your your interpretation of how the law is applying to your situation. I mean, it's hard to dispute. I mean, what are they going to do? Dig deeper than you did to rebut what you're asking the court to move? Okay, let's continue here. Replevin, trespass, and trover, also known as conversion. Okay, so trover and conversion are similar. Are concurrent remedies for a wrongful taking of goods. So concurrent mean they can run at the same time. Actions in replevin are analogous to the actions of trespass, but replevin is in part a proceeding in rem property to regain possessions of goods and chattels, which is your movable property, right? And in a part proceeding in personam to recover damages for the caption and detention. So a couple of words I just want to get right on this one too, because we get caption And I'm not sure about how they're using it here. So let's look what that means there. And also I'm looking at, see here, 9th edition Black's Law. So we're looking at a pretty recent. I do like to look at the older ones because they also have case law in them with the definitions. And the newer ones, they have some, but not for everything. And just bear with me because it's not searchable. I got to kind of page through it, and it's digital, so it takes a second here. Jeez. A lot of words in this. Okay, hang on. Okay, so a few other things. Let's look at another word we have in here that we keep coming across, and I'd like to give just a really good definition. Is chattel, because I just passed it here, and I think that's a good one for us to really get solid, because this is going to keep coming up more and more. So chattel is movable or transferable property, personal property, especially an object capable of manual delivery and not the subject matter of real property. You get that? That money is not to be accounted goods or chattels because it is not of itself valuable. You get that? Money is not chattel. Chattels are either personal or real. Personal may be so called in two respects. One, because they belong immediately to the person of a man, as a bow, a horse, etc. Those are chattel. You got that? The other, for that being any way injuriously withheld from us, we have no means to recover them, but personal actions. Chattels, real, are such as either appertain not immediately to the person, but to some other thing by way of dependency, as a box with charters of land, apples upon a tree, or a tree itself growing on the ground, or else as are issuing out of some immovable thing to a person as a lease or rent for the terms of years. So you get that? It's a personal chattel is a tangible good or an intangible right, such as a patent. The chattel real is real property interest that is less than a freehold or fee, such as a leasehold estate. The most important chattel real is an estate for years in land, which is considered a chattel because it lacks the indefiniteness of time essential to real property, also termed real chattel. Then there's chattel vegetable. There's all kinds of chattels. Chattel paper, a writing that shows both a monetary obligation and a security interest in a lease or a lease of specific goods, and that's under a Universal Commercial Code, right? Chattel paper is generally used in a consumer transaction when the consumer buys goods on credit. The consumer typically promises to pay for the goods by executing a promissory note, and the seller retains a security interest in the goods. See security agreement. Chattel paper means a record or records that evidence both the So we get chattel is a very complex issue in and of itself. Yeah, chattel is but it's not a simple definition. It's pages of definitions if you really get it, because there's so many kinds. There's local chattel, personal chattel, real chattel, unique chattel, chattel lien, chattel mortgage, chattel bond mortgage, chattel paper. I could go on and on with the chattel. So, but each of them have distinct definitions you need to be aware of where they apply. Okay, I mean there's chattel vegetable. Come on. So there we go. And the other word we were looking up was. Now trespass, replevin. Where was it? Well, we'll get back to that. I'm glad we get over chattel because, all right, we got line 1 in here too. Excellent. So we're going over the replevin. So let's continue. Replevin, trespass, and trover, also known as conversion, are concurrent remedies for a wrongful taking of goods. Actions in replevin are analogous to the actions of trespass, but replevin is in part a proceeding in rem to regain possession of goods and chattels, and in part a proceeding in personam to recover damages for the caption in detention. So captions is I guess the taking of, right? Replevin sounds both in tort and in contract. And that part of the remedy that provides for damages for the value of the property is traceable to the common law writ of trover. We're going to find out what that is. However, even at common law, it was recognized that there is an overlap as to these actions. The statutory form of action of trover may be employed in any case in which replevin, detenue, or trover could be used at common law. Yet, there are some differences between the actions. Let's see here. For example, the purpose of replevin is a return of property, not the recovery of damages for the seizure or the value of the property as in trespass, trover, or conversion. You get that? So replevin is not only primarily, and remember, it can also be used for damages for the loss of use during its detention, but it's primarily used for the return of the property. Another thing we learned about replevin is it's used for the timely return of property before a judgment. So that's, I think, what we could chalk up for replevin to keep it very simple at this point. But now we also have to think about trespass, trover, or conversion. All right, so I think property which can be replevied, generally personal property. So let's look here. Replevin is the proper remedy in most jurisdictions to recover the possession of every kind of personal property to which the plaintiff has the right to present or immediate possession. A replevin statute, now this would be in statutory law, whereas replevin is a common law action. Replevin statute may not distinguish between tangible and intangible property. Again, the intangible property could be a patent. Replevin may be utilized to recover possession of dogs. However, not all property can be replevied. For example, replevin cannot be maintained to recover real property, although causes of action for conversion in replevin of a property severed from realty do not involve real property, since the severance of fixtures and improvements from land changes in the character of the property from real to personal, irrespective of the means by which it is accomplished. We're not talking about that in this subject, this topic today anyways. The goodwill of a business is also not subject to replevin. The goodwill of a business. So as an intangible property being goodwill, perhaps as an element of social capital, but that'd be hard to quantify. So I can see why here. Furthermore, replevin cannot lie for a property that is incapable of identification and delivery. So I guess that's where title might fall into this. Under federal law, a property taken pursuant to a revenue law is not subject to replevin. By way of example, since a damage award is not an identifiable chattel, it cannot be replevied. For examples of goods and chattels that can be replevied include insurance policyholder records and files of premium records, a tenant's personal possessions that are being held by the landlord, and patient records. Interesting. So let's hear this again. This is pretty good. By way of example, since a damage award is not an identifiable chattel, it cannot be replevied. Examples of goods and chattels that can be replevied include insurance policyholder records and files of premium records. You can replevy these. A tenant's personal possessions that are being held by a landlord. And patient records. So you can actually replevy your patient records. All right, let me take a break here. Practice tip. Hey guys, you want to learn to practice. The plaintiff in a replevin action must be able to establish having possessed goods or chattels within the meaning of a replevin statute, if any, and that the plaintiff has a property interest in the property that was detained. So there you go. Property interest has to be proven with fact. Title would suffice in this, and any other kind of evidence that would be admitted as far as a property interest. And that's the Also, if there's statutory requirements, if a statute is applicable in your case, if your state has a Replevin statute, then it would be according to the meaning of that Replevin statute. So again, those are things to keep in mind. And that's your practice tip. Find out if your state has a Replevin statute. That's the homework. Because if it does, then that's what you need to study more deeply, because then you don't need to worry so much about these common law applications that we're discussing today. So I think we're pretty much buildings. We're not going to go over deeds. We're not going over, but I think we get to the money is reclaimable as Replevin. Let's look at this here, because this is going to help us with distinctions too. Because if money is seized from you, then you may want to find a remedy for that too, and you want to know whether you want to look into the Replevin or if it's just a waste of time. Let's find out. Money is not subject to Replevin unless it is marked or designated in some manner so as to become specific as it regards to the power of identification, such as being in a bag or package. Wow. You see that, do you? Unless the money's not subject to Replevin, unless it is marked or designated in some manner so as to become specific. Marked bills, right? Or specific as it regards to power of identification, such as, I love the examples they give you in American Jurisprudence, being in a bag or package. So just by placing your money in a bag or package makes it available to be reclaimed through a Replevin action. Similarly, currency that is commingled with similar money is not the proper subject of Replevin action, but such action is proper if specific bills and coins are identifiable due to serial numbers or special markings, or if bills and coins are located uncommingled with an identifiable container or at a specific place. Thus, the general rule is that Replevin will lie for money capable of specific identification. You guys get that? Keep serial numbers of your bills and you can actually reclaim them. In a Replevin action, the description of the property sought to be recovered must be stated in the complaint with reasonable certainty. Thus, a complaint that contains no allegation showing that the defendant had possession of any specific money capable of identification, but that shows only that the defendant had collected for the plaintiff a draft deposited by the plaintiff in the usual course of business, is insufficient. The same proposition applies to monies on a deposit in a joint bank account that are not specifically identifiable so as to qualify the money as being subject to Replevin. Additionally, a petition that merely demands the return of money seized by a police officer does not state a cause of action for Replevin if the petition does not specifically identify the money. You guys get that, right? Let me read that again. No, not a bank transfer. Uncommingled means that you have it separated from the other ones that are not subject to Replevin. So let's get back to this last sentence because it's very important. A petition that merely demands the return of money seized by a police officer does not state a cause of action for Replevin if the petition does not specifically identify the money. So if the petition specifically identifies your money, then it will be valid for money seized by a police officer. Okay. Let's see here. So money is an exception to the general rule that the owner of stolen property can recover it or its value from someone who has received it because of the necessity that the money pass freely in commercial transactions. And then we have so Florida 5th District Court of Appeals, 1986. And then we get to the bank accounts, passbooks, negotiable instruments, and stock certificates. I think someone had a question about that. Certain situations, Replevin may be maintained for a bank account. However, in others, a bank account balance is considered an intangible asset. Negotiable instruments and stock certificates, promissory notes, considered okay. So I don't see anything here about transfers. Not the right to the property it represents. So, caution. Here we go. Simply because funds can be found in a bank account alone does not mean that the funds are subject to replevin. For example, in the case of funds deposited into an attorney trust account, such funds, once deposited, are no longer in the attorney's possession and thus are not subject to replevin. Ah, trust account. You get that? Once you deposit into your attorney's trust account, they're no longer in the attorney's possession. They're in the trust possession. You get that? He might be able to access them, but they're not in his possession legally. Trust. That's your trust. All right, so we're coming up upon the hour mark, and we're ending at, what are we at? Let's see here. Do we make it to the end? Requirements for replevin. Plaintiff have title to right or possession of property. Well, we got a lot. This really goes on for quite a bit, but this is a good place to stop, I believe, because we're at section 11. So we've made it up to section 10, guys. That was great. I mean, this is invaluable information because of the nature of interactions that a lot of us that try to really express our freedoms, that we can find ourselves in positions where the replevin may come into use for us, that we might find that the replevin would help us recover our property in a timely manner and give us time and a little bit of less anxiety to be able to proceed with any kind of unlawful action we found taken against us. It gives us time to work out remedies for any kind of situations without being deprived of our property during those procedures, and prevents anyone from preempting damages being prescribed to you before a judgment. So we got some great things that I hope everybody learned about the replevin. I hope that next time somebody is in a position where they can use a replevin, where they've had property that's been taken from them unlawfully and they need it back, that they'll think about this replevin, that they'll think about American Jurisprudence, Volume 66, and they'll think about these case laws and these strategies and these concepts that any person can understand, and why it's so important to know this stuff being an American, because American jurisprudence is the foundation of our law here. It's the foundation of why we have the best legal system, whether you like it or not, around the world. And this American jurisprudence is a foundation of what makes it such a great system for us if we want to use it. Yes, there's a lot of people that are in positions of government that are misusing a lot of these tools, but it's up to us to know how they're supposed to be used correctly, and then demand that our public servants maintain a public trust and don't abuse it for their own personal profit. And what I want to say is that if anyone here wants to have a nice musical reprieve after this, and to really be able to contemplate this in a great state of mind, I don't know if Audit Them is going to continue a musical stream, but we could go to his channel afterwards if everyone would like to do that. I think it's a great way for us to be in the right state of mind to contemplate what we've just learned today, and perhaps be able to internalize it in a way that we can help others too, or ourselves, should it ever come a time where we'll need this information for a peaceful remedy and bring order with law and not chaos and distress to people, which is our goal here, is really to keep order for everybody and peace, so that we can express life, liberty, and our pursuit of happiness. And part of our pursuit of happiness is our property and protecting our property. And a replevin is a common law remedy to ensure that our property is protected should it unlawfully be taken from us.